Hello everyone, this is amanpreet from Guru Nanak Dev University and I'm a legal intern at LEXIS and Company. So today we are going to talk about restitution of conjugal rights. So first of all, a degree of restitution of conjugal rights implies that the guilty party is ordered to live with the aggrieved party. So restitution of conjugal rights is the only remedy which could be used by the deserted spouse against the other. So this concept comes into place when one of the spouses denies any of the marital rights to other spouse. For instance, if a husband denies his wife to stay with him under the same roof, it is a violation of conjugal rights. Also, Section 9 of the Hindu Marriage Act doesn't violate the Article 14 and Article 21 of the Constitution. It is a misconception that it violates such articles. It cannot be said that the restitution of conjugal rights violate Article 14 and 21 of the Constitution. The only purpose of the restitution of the conjugal rights is to prevent the breakup or breakdown of marriage between the two spouses. So Section 9 states that when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statement made in such petition and that there is no legal ground why the application should not be granted or should not be accepted, may accepted or grant such degree of restitution of conjugal rights. So there has been an explanation attached with it also. So where a question arises whether there has been a reasonable excuse for withdrawal for the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from society. There are certain requirements of restitution of conjugal rights. So first of all, the withdrawal by the respondent from the community of the petitioner. It is one of the ground. Then comes the withdrawal is without any reasonable justification or excuse or lawful ground. Then there should be no other lawful ground for denial of the relief. The court should be filled with the truth of the observation made in the petition. So the truthfulness of such petition must be proved here. Then comes that the petition for restitution of conjugal rights can be filed by both the spouses, either be it husband or be it wife. Both have the right to file for restitution of conjugal rights. So one cannot go for this right if any ground of such on which the respondent could have asked for the nullity of marriage, decree of judicial separation, or even for the divorce, or we can say any conduct on the part of the petitioner or fact that may be compatible with the petitioner taking advantage of his or her wrong or any disability for such relief. Then comes that any other reasonable excuse for the withdrawal for the society of the petitioner. In such cases, he can't go or she can't go for the restitution of conjugal rights. So then there are certain limitations also in regard to the conjugal rights. So even on the refusal of accepting the degree of restitution of conjugal rights, the aggrieved spouse has to wait for 1 year. So with the petition of the restitution of conjugal rights, alternatively the petition of divorce cannot be filed. We can't say that at one side we are filing for restitution of conjugal rights and on the other we are filing for a divorce. Then it is also believed that these prayers are mutually destructive of each other, therefore must be filed after the failure of the previous ones only. There was a case, that is Sushila Bai case, and in this case Supreme Court observed that husband was insensitive towards his wife after marriage also, after so much time of marriage, so it was a valid reason to grant such right. Then under section 25 one can ask for maintenance along with the restitution of conjugal rights. Then comes order 21, rule 32 and 33 of the Code of Civil Procedure, which executes such right in which the respondent against whom the order has been passed can follow it or willfully disobey it, and the decree is to be attached with the property. Then comes under section 13 clause 1 subclause E of such, if after obtaining of the restitution of conjugal rights there is no such restitution for more than 1 year, then one may go for divorce with it being a valid ground for the same. So that was all about restitution of conjugal rights. I hope you like this video. If you like this video, put a thumbs up on this video, and also don't forget to like and subscribe the channel LEXCLIQ. and this does not solicit any promotion or advertisement. As per the guidelines of the Bar Council of India, it is for education purpose only. Thank you.